Dear students, viewers, and the subscribers, welcome to the IAS Mentor. So, today we are there to discuss certain practice questions. Today, we are not going to discuss any concepts, but rather we are going to revise the concepts that you have already learned through the practice questions. So, I have been stressing upon many times in this particular series itself that what is equally important is also the revision. So many times students, they are not able to do well in the examination because they fail to revise. And revision through questions, solving questions is the effective way. So of course you have to revise, and after revising again you do a lot of practice question, you do a lot of previous year questions that is going to help you in performing well in the examination. And I would say today this lecture number 50, we are also coming to a milestone, which I would say because we have covered some substantial portion of syllabus so far. We have started from the very basics, and today this practice test will have questions from all the areas that we have revised till this point of time, that we have discussed and seen till this point of time. So I would say the major topics we have started right from understanding what is a constitution, the historical background during the British rule in India, and then we have understood the topic of Constituent Assembly, we have understood the preamble, we have understood the Union and its territories, we have understood the topic of citizenship, fundamental rights, directive principles of state policy, fundamental duties, amendment to the Constitution, basic structure. So around 10 topics majorly has been covered, but still yes, we are in a long way to go before we complete this particular series, and thereby we'll give a comprehensive idea on the subject Indian polity. But still we have covered some substantial portion. For the beginners, you have some substantial idea as to what the Constitution of India is all about. So we'll try to discuss all those whatever we have covered in the form of what is called as the practice question. Please look into the question number 1. Consider the following statements regarding the Constituent Assembly of India. So we have seen about the Constituent Assembly of India, a body which drafted the Constitution of India. That's basically what is the Constituent Assembly. And if you see this Constituent Assembly of India, this body was designed by what is called as the Cabinet Mission Plan. So they came to India, and this body is largely to have representation from both princely states as well as the provinces, and there were some nomination from the commissioner provinces also. So regarding this body, let us try to answer the question. The assembly was completely an elected body. No, the assembly was not completely an elected body, because the members from the British provinces, there was an indirect election, but there was no election for the members from the princely states, and in case of commissioner province, in both the cases it was by way of what is called as nomination. So this statement is wrong. The members of the Constituent Assembly was elected through universal adult franchise. No, the members of the Constituent Assembly were in fact elected indirectly. They were elected through indirect election. So they were elected by the elected members of the provincial legislature. So it was only a system of indirect election. That is also wrong. The Constituent Assembly had representation only from the British provinces. So mostly in UPSC also, whenever they use the word only, exclusively, so all these extreme words which is there in a particular statement, and such statements are usually wrong. Okay, so it cannot be always wrong, but mostly they are wrong. Suppose if you have to take an educated guess, you can use certain hints like this. So how you can arrive at all these things? Only when you learn UPSC language. And to learn UPSC language, you'll have to solve a lot of UPSC questions. So that will help you to learn all these things. So the Constituent Assembly had representation only from the British province. So that is also wrong. So which of the statements given above are incorrect? So when you talk of which of the following is incorrect, I would say the answer is statement 1 is incorrect. Statement 2 is also incorrect. Statement 3 is also incorrect. Which of the statements given above are incorrect? Okay, I'll just make a changes in the option. So which of the statements given above is incorrect, or I would just make a change. How many of the statements are incorrect? How many? So there's some typo here. So how many of the statements given above are incorrect? So I would say 1 only, I would make it 2 only, 3 only, and I'll make it none. So how many of the statement is incorrect? Statement 1 is incorrect. Statement 2 is also incorrect. Statement 3 is also incorrect. So the answer is 3 only. So option C is the right answer. So some mistake has happened. So that's okay. I have just made a change in this particular question. So come to the next question. Consider the following statements regarding the provisions of the Constitution. So this is a question from Union and its territory. So I'm trying to touch upon all the areas that you have discussed. Statement 1, creation of new states in India by reorganizing the existing territory can be done only by the Parliament of India. So creation of new states in India by reorganizing the existing states. So this is done under Article 3 of the Constitution. So any internal reorganization is done under Article 3. And Article 2 is talking about acquiring a new territory. So some territory outside the territory of India into India is done under Article 2. So any internal reorganization is done under Article 3 and it is only the power of the Parliament. So this is also true. So no other authority has power in this regard. A union territory can be conferred the status of a state by an act of Parliament, but vice versa is not possible. An union territory can be converted into a state can also be converted into union territory. All these things can be done under Article 3 of the Constitution, and the Parliament has the power to do that. It is not only that, to increase the area of a state, to decrease the area of a state, to alter the names of the state, all these things can be done under Article 3 of the Constitution. So this is wrong. A union territory can be conferred a status of a state by an act of Parliament, but vice versa is not possible. A state can be converted into a union territory. Yes, that is very much possible. The state of Jammu and Kashmir is now converted into union territory of Jammu and Kashmir and Ladakh. So yes, that's very much possible. So this is wrong. The approval of the concerned state legislature is mandatory before reorganizing the states. So the approval is not mandatory. So it is not the approval that is mandatory. It is only the referral of such a bill to the concerned state by the president is mandatory. Okay. So the moment you say it is approval, then it is wrong. So which of the statements given above are correct? So they're asking for the correct statement. So out of the correct statement, so only one is the correct statement. So remaining 2 and 3 are wrong statement. So the answer is B only. Okay, or option B, that is 1 only. So come to the next question. Consider the following statements regarding the preamble to the Constitution of India. They are the key to unravel the minds of makers of the Constitution. So this is exactly what the Supreme Court of India has said with regard to the preamble. Yes, they are key to unravel the minds of the makers of the Constitution. Statement 2. They are integral part of Constitution, but neither give nor take away the powers of the organs of the state. So they are integral part of the Constitution, but they neither give nor take away the powers of the organs of the state, which is also very true, which is what the Supreme Court of India has said. The Supreme Court of India in the Keshavananda Bharati case has clearly said that the preamble is an integral part of the Constitution. But before the Keshavananda Bharati case, there was a case where the Supreme Court told that the preamble is not an integral part of the Constitution. If you know the name of the case, you can put it in the comment box, which I already discussed. But whether the preamble is an integral part of the Constitution, yes. Today, as per the Keshavananda Bharati case, they are an integral part of the Constitution. But the Supreme Court has made it very clear, though they are an integral part of the Constitution, the purpose that they serve was to interpret the other provisions of the Constitution. If there is any ambiguity, those ambiguity may be resolved by using the preamble. But otherwise, the preamble is neither a source of power nor takes away the powers of the organs of the state. So to that extent, you see, this particular statement is true. They are an integral part of the Constitution, but neither give nor take away the powers. They can be amended without any restrictions. So that means, can they be amended? The question is true if you ask whether they can be amended, but can they be amended without any restriction? That makes the statement an extreme statement. Whenever an extreme statement is given, you'll have to be a little cautious about these extreme statements. I said that most of the extreme statements are always wrong. So in this case, whether it is right or wrong. So they can be amended without any restriction. No, that is not possible, because they can be amended subject to the basic structure doctrine. So we already learned as to what is basic structure. So basic structure doctrine is saying that the power of the Parliament is not unlimited. Rather, it is limited to the extent that the parliament cannot destroy what is called as a basic structure in the constitution. So while the preamble can be amended, but the basic features in the preamble cannot be destroyed by that amendment. So to that extent, without any restriction makes it wrong. So which of the statements given above are incorrect? So incorrect is option C, that is statement 3 only. Please come to the next question. Consider the following statements. Statement 1, the Constitution of India allows its citizens to possess multiple citizenship of different countries at the same time. That is not possible. The Constitution does not allow for what is called as dual citizenship. Neither the Constitution nor the Citizenship Act, which governs citizenship subsequent to the commencement of the Constitution, both does not recognize and allow for what is called as dual citizenship. So that is not at all possible. Only person born in India can acquire the Indian citizenship. No. As a person born in India or within the territory of India, they can acquire the Indian citizenship through by virtue of what is called as citizenship by birth. But somebody born outside the territory of India, they can also acquire the Indian citizenship by virtue of what is called as descent. Even the foreigners can acquire the Indian citizenship by virtue of what is called as naturalization and registration. And they can also acquire the Indian citizenship by what is called as incorporation of territory. So these things are all possible. Only persons born in India can acquire Indian citizenship. That is again an absolute statement. So here it is used only. So only means mostly it is wrong. I'm not saying it is always wrong, but mostly it is wrong. You should think a couple of times in case of extreme statements. Only citizens of India will have the right to vote in general elections to India. So yes, this is here it is right. So here this is definitely true because it's only the privilege of the citizens to right to vote in the elections. So this is true. Which of the statements given above are incorrect? If you see incorrect statement here, so it is asking for what is incorrect. So incorrect statement would be 1 and 2 only. Option A is the right answer. Please come to the next question. What is the majority required in the parliament to amend the provisions of Citizenship Amendment Act 1955? So for which you will have to first understand what type of act is this. Is it a simple act of parliament? Is it an ordinary law? Is it a constitutional amendment and all those things? So Citizenship Amendment Act is a simple act. It is an ordinary law. So any ordinary law to amend or to get passed in the parliament, that requires what type of majority? That requires what is called as a simple majority. Alright, so that's a basic understanding you should have. And what is a simple majority? Simple majority means majority of members present as well as voting. So the majority of present as well as voting, P for present as well as voting. A majority of this would be simple majority. Say for example, if 500 members are present, what would be the majority? The majority for 500 is 251. But this is not what is simple majority because we are seeing only how many are present. But to calculate the simple majority, we'll have to see how many are voting in this 500. So suppose out of this 500, only 450 members are voting. So the present and voting would be 250. So in this, what is a majority? In present and voting. So here would be 226. 226 would be the simple majority. And it would further reduce. Say for example, instead of 450 members, only 400 members are voting. So present and voting would be 400. So in this particular case, the majority would be 201. That would be simple majority. So this is the way we calculate what is called as simple majority. And the majority that is required in case of passing an ordinary bill or any ordinary law is basically what is simple majority. So the answer here is option A. What is absolute majority? What is special majority? What is special majority with ratification by half of the states? I have made a separate video on all the majorities. So please go back to those lectures and try to revise all those things. Okay. In fact, all the practice question will be extremely useful if you have seen all the lectures. And then if you come to the questions, it will be of lot of use. Come to the next question. Recently, India has exchanged some of Indian enclaves with Bangladesh, thereby giving some of the territories to Bangladesh and acquired some territories from Bangladesh. In doing so, the law in India allows people living in those acquired territories to become citizens of India immediately through which of the following provisions? In fact, this is true. In fact, which amendment through which India has ceded a territory to Bangladesh? In fact, this is what I discussed with regard to the exchange of enclaves between India and Bangladesh. So India has exchanged some of the Indian enclaves inside Bangladesh. It has given it to Bangladesh, and some of the Bangladesh enclaves in India, India has taken it. And for which the amendment that was passed was the 100th Constitutional Amendment Act. Why a constitutional amendment is mandatory is because that whenever you cede a territory to a foreign country, it can be done only by way of a constitutional amendment under Article 368, which the Supreme Court in the Birbar Union case has already clarified. So this is what is the entire picture is all about. But now the question is, when India is giving some of the territory to a foreign country, it can be done only by way of a constitutional amendment. But if you see here, this is about what is exchange of enclaves in this particular case between India and Bangladesh. Exchange of enclaves means India is giving some territory to Bangladesh, and in return we are taking some of the territory of Bangladesh into India. So this is basically what is called as exchange of enclaves. So enclaves is a small territory of one country which is surrounded completely by another country. So some Indian territory is completely inside Bangladesh, some Bangladesh territory completely inside India. So whatever our territory inside Bangladesh territory, we are giving it to them. Whatever their territory, small packet of land inside India, we are taking it. So what will happen to all those Bangladesh citizens living in the enclaves inside India? So what will happen? Will they be given the Indian citizenship? Yes. There is a provision under the Indian Constitution that allows them to take up the citizenship, and it is based on the provision of what is called as incorporation of territory under the Citizenship Act 1955. So we have already learned this. Come to question number 7. Consider the following statement. Statement 1. A constitutional amendment can be challenged in a court of law for the violation of the fundamental rights. Can a constitutional amendment be challenged in a court of law for the violation of fundamental rights? So we have seen it very clearly during our discussion on the basic structure doctrine that no constitutional amendment can be challenged in a court of law merely on the ground that it is violative of what is called as the fundamental rights. That is not possible. The only ground on which a constitutional amendment can be challenged in a court of law is for the violation of what is called as a basic structure in the Constitution. In fact, Article 13 was amended by the 24th Constitutional Amendment Act, which made it very clear that a constitutional amendment is not a law under Article 13, and hence if a constitutional amendment is violative of fundamental rights, they cannot be challenged in a court of law merely on the ground it is violative of fundamental rights. The only ground on which a constitutional amendment can be challenged in a court of law is on the grounds that it is violative of what is called as basic structure. So to that extent, this particular statement is wrong. A constitutional amendment can be challenged in a court of law for violation of the fundamental rights. No, unless and until the fundamental right is part of the basic structure. A constitutional amendment can be the constitutional amendment can amend any provisions of the Constitution, including the fundamental rights, without any limitations. When you say without any limitation, that's an absolute statement. Absolute statement means you'll have to be very careful. Without any limitation is not possible, because the Supreme Court in the Keshavananda Bharati case has put in a limitation. And what is that particular limitation? That limitation is in the form of what is called as basic structure doctrine. So to say that without any limitation is a wrong thing. So to that extent, this particular statement is also wrong. Which of the statements given above are incorrect? So both 1 and 2, option C is the right answer. Please come to the next question. The fundamental right to freedom of speech and expression can be restricted by the state on what grounds? So we have seen that the right under Article 19. So there are 6 sets of rights today under Article 19. The original Constitution has provided for 7 sets of rights, whereas the right to property has been repealed from the Constitution. But whatever exists today, all the 6 sets of rights, they are all subject to certain reasonable restrictions. And what are the reasonable restrictions? That is also given in the Constitution. In fact, the right to freedom of speech and expression can be reasonably restricted on 8 grounds. They can be restricted on the grounds of sovereignty and integrity of India. They can be restricted on the grounds of security of the state. They can be restricted on the grounds on the grounds of affecting the friendly relations. They can be restricted on the grounds of public order. They can be restricted on the grounds of decency and morality. They can be restricted on the grounds of contempt of the court. They can be restricted on the grounds of defamation and incite to an offense. So these are the 8 grounds that is mentioned in the Constitution. All these 8 grounds, the law can be made, and accordingly the right to freedom of speech and expression can be restricted. So with that, come to the answer. The fundamental right to freedom of speech and expression can be restricted on disturbance to public order, yes. Incitement to offense, yes. Against decency or morality, yes. Defamation, yes. Contempt of the court, yes. So what is the right answer here? So the right answer is all of the above. In fact, you may remember all the 8 grounds also. Sometimes it may be asked in the examination. So the answer for this particular question is option D. So come to question number 9, EWS reservation. So this EWS reservation was brought in by the 103rd Constitutional Amendment Act 2018. This amendment passed. It inserted 2 important articles into the Constitution, that is Article 15 Clause 6 and Article 16 Clause 6. Article 15 Clause 6 is talking about EWS reservation in educational institutions. And whereas Article 16 Clause 6, EWS reservation in public employment. Alright, so this is the fundamental idea with regard to EWS reservation. So now come to the question. EWS reservation recently in news provides reservation to economically weaker sections of the society, including scheduled caste, scheduled tribe, in both educational institutions and public employment. The Supreme Court has made it very clear that the EWS reservation is a separate category of reservation. So the EWS reservation, as per the Supreme Court ruling, excludes the other backward caste, scheduled caste and scheduled tribe. That means EWS reservation is a reservation for the general community, but who are economically weaker among the general community. So this would be wrong. Economically weaker sections of the society, excluding scheduled caste, scheduled tribe and other OBC community, only in educational institution. This is partially right, but because of only in educational institution, this is also wrong. Third, economically weaker sections of the society, excluding scheduled caste, scheduled tribe and the other OBC communities in both educational institutions and public employment. Economically weaker sections of the society, including scheduled caste, scheduled tribe, in only public employment. This is also wrong. So the right answer is option C. So it requires proper clarity on the concepts and also some facts. Of course, facts are also important for you to solve the questions. Please come to the next question. In the Constitution of India, promotion of international peace and security is included in which part? So that is why I said one major theme where UPSC usually focus on is that you should be very clear as to what is a fundamental right, what is directive principles of state policy, what is fundamental duty, and what is also mentioned in preamble. So sometimes they can pick some statements or they can pick one fundamental right or one DPSP, they can put it and they can ask you where it is mentioned. Is it part of fundamental rights? Is it part of DPSP? Is it part of preamble? Is it part of fundamental duty? You should be very careful about it. One question you may expect definitely from this particular area. So the answer here is, in the Constitution of India, the promotion of international peace and security is included in what is called as directive principles of state policy. In fact, if someone know the article under which they talks about promotion of international peace and security, in fact, this is the last directive principles of state policy. Sorry. If you know the article number, you can put it in the comment box. Come here. Next question. Consider the following statements. Reservation in private sector jobs to residents of a state is violative of fundamental right under Article 16. If a job is reserved in the private sector, is it violation of Article 16? So what is Article 16 is saying? Article 16 is saying that there shall be no discrimination when it comes to public employment and no discrimination on the grounds of religion, race, caste, sex, place of birth, residence or any of them, descent, any of them, but only in public employment. It is not talking about what is called as private employment. Say for example, today a lot of states, for example, states like Haryana and certain other states also, they have also reserved seats for local residents. certain jobs in private sector employment. So that cannot be seen as violation of Article 16. So if the word is public employment, probably then that is the right thing. So here it is not the right thing. The Constitution empowers the Parliament to reserve the jobs for the residents of a state in public employment by a law. Yes, this is very much true, and in fact the only authority who has got the power to do this, to reserve certain jobs to the local residents, be it an employment under the central government or the state government, but who is supposed to make a law, and by that law to reserve jobs to the local residents, it is only the power of the Parliament. And this power is given to the Parliament under Article 16 Clause 3. We have discussed all those things. You can refer to them, the previous lectures. So which of the statements given above are incorrect? So here the incorrect statement is option A only. That is 1 only is the incorrect statement. Come to question number 12. Which of the following provisions can be amended by the Parliament? So we know that the Parliament has a power to amend the Constitution. And which article is giving this power to the Parliament? Article 368. Under Article 368, the Parliament can give the has the power. But what you'll have to keep in your mind is under Article 368 of the Constitution, while the Parliament can amend the Constitution, but it is not a limited, it is not an unlimited power. It is not unlimited, but rather it is what is a limited power. So this is what the Supreme Court has told in what is called as the Keshavananda Bharati case. So keeping this in mind, come here. Which of the following provisions can be amended by the Parliament? Can they amend fundamental rights? Yes. They have the power to amend fundamental rights. Can they amend DPSP? Yes. Can they amend fundamental duties? Yes. But can they amend them in total? No, not possible. Because whatever is declared to be part of the basic structure, they cannot be amended. But the question is nowhere trying to assess your understanding of basic structure. So it's a very general question which is asking which of the following provisions in the Constitution can be amended. So it's not asking which of the following provisions can be amended in total. Then you will have to think about the basic structure and all those things. So that's not the idea here. How many of the above options are correct? 1, 2, 3. So all the 3 are correct. So the answer is 3 only is the right answer. Come to the next question. Question number 13. Consider the following statements. A constitutional amendment can be challenged merely on the grounds of that it is violative of the fundamental rights. So can any constitutional amendment be challenged merely on the ground that it is violative of the fundamental rights? It is not possible. We already seen clearly during our discussion on doctrine of basic structure. The only ground on which any constitutional amendment can be challenged is on the grounds of violation of the basic structure doctrine. So unless and until you prove that it is violative of the basic structure, a constitutional amendment cannot be challenged in a court of law. Okay, so that's the only ground, not merely on the grounds it is violative of fundamental rights, unless and until that fundamental right is also part of the basic structure. Say for example, Article 14 is part of basic structure, Article 19 is part of basic structure, Article 21 is part of basic structure. So if these fundamental rights are violated, they can be challenged, but not every fundamental right in part 3 has been given the status of what is called as basic structure by the courts. Only the Parliament can amend the Constitution. This is true. This is an extreme statement, but this is true. No other authority under the Constitution has the power to amend the Constitution. So choose a correct answer from the quotes given below. So the answer is 2 only, that is option B, because statement 1 is wrong. Come to the next question. If a constitutional amendment bill is trying to amend the federal provisions of the Constitution, that means the bill is introduced, but that constitutional amendment bill is trying to amend the federal provision. Say for example, it is trying to amend the Schedule 7 of the Constitution. Say for example, it is trying to cover the powers of the Supreme Court of India. It is trying to alter the position of high courts in India. These are all considered to be federal provisions. So whenever any federal provision is amended, it was disturbing the power balance between the center and the state. So what is the procedure that is required? We already seen. The procedure that is required in all these cases is, first of all, it has to be ratified by special majority in both the houses of the Parliament. After it is passed by special majority in both the houses of the Parliament, then it also requires approval of whom? Then it also requires approval of what is called as ratification by not less than half of the state legislature as well. So that's what basically you'll have to understand. If a constitutional amendment bill is trying to amend the federal provisions of the constitution, it requires what? It requires ratification by all the state legislature. No, that is not the right thing. More than half of the state legislature, that is also not right, but not less than half of the state legislature. That means it has to be ratified by at least half of the state legislature. But this is after it is passed by special majority in both the houses of the parliament. So the right answer is option C. Who among the following can introduce a constitutional amendment bill? So that means we have already learned when you discuss the procedure for a constitutional amendment bill under Article 368. We have learned all these things. We have learned that a constitutional amendment bill can be introduced in either houses, be it in Lok Sabha or in Rajya Sabha. And once it is introduced, it needs to be passed with special majority. But who can introduce that? We have seen that it can be introduced either by a minister or by a private member. Not necessarily only by a minister. Anybody can introduce that. Okay. So who among the following can introduce a constitutional amendment bill? Only a minister is wrong. Only a private member is wrong. Both a minister and a private member. Who is a private member? Anyone who is not a minister, be from a ruling party or from an opposition party. Any member of parliament who is not a minister is a private member. That means these two concepts are mutually exclusive. So ministers and whoever is not minister and a member of parliament is a private member. So how many of the statements given above are incorrect? So incorrect is statement 1 and statement 2. So the answer is option B, 2 only. All right. Okay, so with that we have come to the end of this particular discussion. So if you see the discussion, the question that I have discussed, I have picked up questions from all the areas. I have picked up questions from union and its territories. I have picked it from preamble. I have picked it from citizenship. I have picked it from constituent assembly. I have picked it from the citizenship. I have picked it from the fundamental rights. I have picked it from the amendment to the constitution. I have picked it from the topic of basic structure doctrine also. So the idea is that to revise whatever you have seen already. So that's why I have kept this particular practice question. So the only area I think I have not kept is the historical understanding, but all other areas is there. So try to revise all those things and try to do a lot of practice questions. That's the only way that you can do extremely well in the examination without any doubt. All right, so with that I'll wind up this particular lecture. In the next lecture I'll start to the executives part. I'll take up the topic of president and then we'll move on subsequently. So another couple of months, I'm quite sure that we will complete the entire topic of or the entire subject of Indian polity. And this is going to be extremely useful. But the only thing that I would say is watch all the lectures chronologically and try to watch patiently all the lectures. It is going to immensely benefit all of you. With that, I'll wind up the lecture. Thank you very much. All the very best.